My sister tried to take all the inheritance and frame me in court. My parents backed her. Minutes later, a man walked in and turned them pale. The bailiff called the case like he was reading a grocery list, and my sister stood up before the final syllable was spoken. She was eager to claim my grandfather rather than to honor him. She wore a tailored cream coat over black. The kind of quiet luxury that makes people believe you're correct before you speak. Her hair was flawless. Her face was dry. And when she looked at me, her eyes were not filled with grief. It was a calculation. Her attorney, in a slick suit, soft voice and expensive watch, approached the counsel table with a thin stack of papers and slid them forward like a blade. "Your Honor," he replied. "We're moving for immediate transfer of the estate to my client, effective that same day." My parents nodded together behind him, as if they had practiced it in the mirror. My mother's hands were folded solemnly, as if she were attending church. And my father stared straight ahead, jaw set as if this were a business meeting and I was the impediment. The judge did not look at them at first. He looked at me. "Mr. Hale," he said, his tone flat. "Do you object?" My sister's lips twitched, as if she could not wait to hear me beg. I did not. I sat up straighter, rested my hands on the table and made certain my voice did not shake. "Yes," I answered. "I object." Her attorney smiled, faintly and patronizingly. "On what grounds?" he inquired, already certain he would walk through me. I didn't give him an argument. "Not yet. I want to wait until the last person arrives," I told them. The judge blinked once. "The last person?" he repeated. I nodded. "Yes, Your Honor." My sister let out a small laugh that was not humorous. "This is ridiculous," she stated. "There is no one else." My father finally turned his head slightly toward me as he used to do when I was a teenager, reminding me that I was embarrassing the family. "You always do this," he muttered loudly enough. The judge leaned back, adjusting his glasses. "Ms. Hale," he replied. "This is probate court, not the stage. If you have an objection, it must be legal." "It is legal," I said calmly. "But it is not my place to explain." My sister's attorney approached, voice smooth. "Your Honor," he explained, "we're requesting an emergency appointment because Ms. Hale has been uncooperative. There are assets that must be protected, and my client is the responsible party." Responsible. That word was always used as a weapon in my family. It meant giving us control and not asking questions. My mother sighed softly, as if she was distressed by my immaturity. "She's grieving," she told the judge. "She doesn't understand how these things work." My sister's eyes remained on me, bright and cold. "I'm just trying to keep everything from falling apart," she told me. "Grandpa would want it handled properly." I stared at her, thinking about how quickly she'd found a lawyer, how quickly the petition appeared, and how polished my parents appeared sitting behind her like backup singers. The judge turned the page in the case file. "This petition requests full authority over the estate," he informed me. "It alleges the respondent is unfit to participate and may interfere." My sister's attorney nodded. "Correct." "And you want me to grant it that same day?" the judge stated. "Yes, Your Honor," the attorney responded. "Is it effective immediately?" The judge looked at me again. "Ms. Hale," he replied. "What's your objection?" I kept my posture constant. "My objection is that they're asking you to act without the full record," I explained. My sister laughed more sharply. "There is no hidden record," she retorted. "He died. This is what happens." The judge's expression remained unchanged, but his patience thinned. "Miss Hale," he informed my sister, "you will not speak out of turn." My father's lips tightened. My mother's eyes narrowed, as if she disliked being corrected. My sister's attorney attempted to salvage the situation with politeness. "Your Honor, if Ms. Hale wishes to delay, we object. The estate cannot wait." I did not look at him. I looked at the judge. "It will not be a delay," I stated. "It'll be a few minutes." The judge exhaled and looked toward the courtroom doors, clearly deciding whether to entertain me. "Whom are we waiting for?" he asked. I responded with the simplest truth I could express aloud. "The person who actually controls the inheritance," I corrected myself. My sister's expression tightened for the first time. "That's me," she said automatically, but stopped herself when the judge's gaze flicked her way. The judge leant forward slightly. "Miss Hale," he told me. "If this is a tactic—" "It isn't," I answered. "I'm asking you to let the record arrive before you sign anything." A beat of silence. Then the courtroom doors opened. Not a dramatic swing, but a clean, controlled push, as if someone was doing something with a purpose. A man entered wearing a black suit so plain it resembled a uniform. There was no flashy tie or jewelry in his hand, only an envelope and a calm expression as if he didn't care who in this room had money. He walked directly to the clerk's desk, not looking at my parents or sister. He held up the envelope, spoke clearly, and mentioned my name. Ms. Hale. The judge blinked, reached for his glasses again, and regarded the envelope as if it did not belong in his courtroom. The man in the black suit did not raise his voice. He did not explain himself. He simply placed the envelope on the clerk's desk with one hand and stated, "This is for the court from the trustee." The judge opened the envelope, read the sender line, and moved his mouth as if he had spoken before he intended to. "That can't be," he muttered. The judge did not open the envelope as if it were regular mail. He held it between two fingers, turned it once, and looked at the return address again, as if the ink would change if he stared long enough. Then he ripped it open. No flourish, just a clean rip, as if he wanted the paper to stop pretending it was more important than what was inside. The courtroom was so quiet that I could hear my sister's attorney shifting his weight. The judge began by pulling out a single folded document. Thick stock, embossed seal in the corner, and a signature block that appeared too formal for what my family had been treating as a family meeting. As he scanned the top line, his jaw tightened. Then he read the sender aloud. Hawthorne National Bank Trust Department. My sister's face flickered for a second before she regained her composure. She'd spent her entire life working with money. Hearing a bank's name in open court should have made her appear powerful. Instead, it made her appear caught. The judge continued reading. "This is a notice of trust administration," he informed me. "It states the decedent's assets were placed into a revocable trust, and that the trust became irrevocable upon death." My sister's lawyer rose quickly. "Your Honor, we're in probate." The judge did not even look up. "Sit down," he instructed. He turned another page. "And this," he said softly, "is a certification of trust identifying the trustee." He paused again, as if the next line contradicted his understanding of how lawsuits are supposed to work. Then he read it. "Successor trustee, Hawthorne National Bank Trust Department." My parents stiffened because they were looking for control. A bank isn't concerned with control in the same way that families are. A bank is concerned about documents, terms, and risk. My sister's attorney attempted to recover with confidence. "Your Honor, even if there is a trust, probate still has jurisdiction over the estate." The judge eventually looked up. "Counsel," the lawyer replied. "Your motion requested all of the inheritance effective immediately." He touched the paper once with his finger. "This trust certification states in plain language that the probate estate is minimal and the majority of assets are held in trust." He turned to face the clerk. "Mark this as received," he stated. Then he looked at my sister. Not as a sister. Not as a family member, but as a petitioner who had just attempted to take something she didn't own. "Ms. Hale," he said to her, "did you know your grandfather established a trust with a corporate trustee?" My sister raised her chin. "He was influenced," she explained. "He didn't understand what he was signing." The judge did not disagree with her feelings. He held up the following page. "This notice includes a copy of the trust's execution affidavit and the list of witnesses," said the lawyer. "It also includes an attorney certification that the decedent signed with full capacity." My father's mouth tightened. My mother's eyes narrowed, as if she were trying to find a new angle. And then the judge came across a line that made him whisper, "That can't be in there in the first place." He read it slowly so no one could later claim they misunderstood. No contest clause was triggered. Any beneficiary who files a petition to seize trust assets in violation of the terms forfeits the distribution. My sister's attorney's face was drained. My sister's eyes widened slightly, then narrowed, as if she was attempting to intimidate the paper into backing down. My mother unclasped her hands for the first time. The judge looked up. "Counsel," he informed my sister's attorney, "you filed a motion for the immediate transfer of all inheritance to your client." "Yes, Your Honor," the attorney replied carefully. "You understand," the judge said, "that this clause is enforceable. The act of filing your motion may already have resulted in forfeiture." The lawyer swallowed. "Your Honor, we dispute the validity." The judge cut him off. "You can dispute it," he said. "But you don't get to pretend it isn't there." He looked at me again. "Ms. A. Hale," he replied. "You asked to wait until the last person arrived. Was this the person?" "Yes," I answered. Despite the fact that my pulse had risen to my throat, my voice remained level. "The trust department is the trustee. They have control over the distribution. The man in the black suit, still standing near the clerk as if he were part of a procedure, spoke for the first time. "Your Honor," he said calmly and clearly, "I am not here to argue. I'm here to provide notice and confirm the trustee's position." The judge gestured once. "State it," he replied. The man did not look at my parents. He did not look at my sister. He looked at the judge. "The trustee does not recognize the petitioner's request," he informed me. "The trustee will not distribute assets to anyone based on the motion filed that same day. The trustee will administer according to the trust terms and has asked the court to dismiss any attempt to seize trust-controlled assets through probate." My sister snapped. "You can't just—" The judge raised his hand. "Ms. Hale," he exclaimed sharply. "You will not speak out of turn." My sister shut her mouth, but her breathing pattern changed. Faster now. Thinner. Her lawyer stood again, attempting to regain ground. "Your Honor, at minimum, we move to compel production of the full trust," he said in response. "We question whether my client was improperly removed or whether there is undue influence by the respondent." The judge's eyes did not soften. "Undue influence is a serious allegation," he told reporters. "And you just watched audio evidence of attempted coercion aimed at the decedent, which did not come from the respondent." My father's jaw twitched. The judge turned back to the man in black. "Has the trustee delivered the trust instrument to counsel?" he asked. "Yes," the man replied. "A complete copy was delivered to both sides the previous afternoon via certified service." My mother's head snapped at my sister's attorney like a whip. The previous afternoon, implying they knew, or should have known, and thus filed anyway. The judge allowed that fact to sink in for a moment before looking at my sister with disgust. "Miss Hale," he asked, "did you get the trust documents the previous afternoon?" My sister's lips parted, and for the first time, she appeared less like an executive and more like a person trapped. She began. Her attorney intervened quickly. "Your Honor, we received a packet, but—" The judge interrupted him. "Counsel," he indicated. "If you received a packet containing a no-contest clause and still filed a motion demanding all inheritance effective immediately, I want you to understand what that looks like to this court." The attorney stood still. The judge turned to face the clerk. "Set a hearing," he insisted, "on standing and sanctions, and I want the trustee's letter entered into the record." He then looked directly at my sister. "And Miss Hale," he said with a colder tone, "if you are a named beneficiary and you triggered forfeiture that same day, you may have cost yourself more than you intended." My sister's face tightened into something unpleasant. Her eyes met mine, and the hatred there was not for money. It was about how the institution she expected to crown her had just labeled her as a risk. Then she did what she always did when she couldn't win at paperwork. She attempted to win with a new story. "Your Honor," she said abruptly, her voice loud, turning to the bench with practiced urgency. "I need to put something on the record." The judge's eyes narrowed. "What?" he stated. "Exactly." My sister looked at me directly and said the one word my parents had been saving like a bullet. "Elder abuse." The judge's expression changed, not because he believed her, but because the court now had to decide whether she had proof or if she was about to commit suicide with another false allegation. "Elder abuse," my sister said louder, as if volume could convert accusation into evidence. My mother's face softened immediately into performance grief. My father leaned back in his chair, his eyes narrowing as if this was the plan they had been waiting to implement. Her attorney stood next to her, as if he had been given an emergency exit. "Your Honor," he stated, "we request an immediate investigation. The respondent isolated the decedent, restricted access, and coerced him into signing documents that benefited her." The judge did not react like a daytime television audience. He acted like a judge. He leaned forward and said, "Counsel, these are serious allegations. What evidence do you have from the same day?" My sister did not blink. "Witnesses," she said, gesturing behind her. 3 relatives stood awkwardly in the back rows, as if they had been drafted. My aunt and a cousin I rarely spoke with. Their expressions were tense and their gazes shifted away from me. My mother nodded encouragingly at them, as if she were coaching them silently. The judge looked at them, unimpressed. "Witnesses can testify," he said. "But I need something concrete. Medical reports, previous complaints, police reports, and APS involvement. Anything." My sister tightened her jaw. "He didn't want to embarrass the family," she explained quickly. "He was scared." The judge's expression remained flat. "Then explain why he called emergency services himself," he instructed. Silence. My sister attempted to pivot. He was confused, she explained. He didn't know what he was doing. The judge returned his gaze to the bank's envelope. Ah, this trust was executed with a capacity affidavit and witnesses, a voice replied. That's not confusion, that's formalized intent. My father's attorney rose, his voice smooth. Your Honor, we also have evidence the respondent had access to accounts and controlled communications. Daniel Mercer rose immediately. Objection, he stated. This is argument without foundation. The judge raised a hand. Counsel, he asked my sister's attorney. Do you have that evidence here? My sister's lawyer hesitated slightly. Then he did what lawyers do when they have a narrative but not the evidence. We would request discovery, he said. The judge's eyes hardened. Discovery is not a fishing license, he explained. You do not accuse someone of elder abuse in open court as a strategy to seize assets held in trust. My sister's cheeks flushed. It's not a strategy, she retorted. The judge leaned back. Then bring the evidence, he said. Not theatrical relatives. My mom's voice trembled. Practiced. Your Honor, she replied. She kept us away. She made him hate us. The judge took one look at her. Ma'am, he replied. This is not family therapy. Then he focused his attention on the one person in the room who had no emotional stake, only fiduciary responsibility. He addressed the man wearing black. Sir, he asked. Does the trustee have any documentation of concerns about undue influence or abuse? The man did not hesitate. No, Your Honor, he replied. The trustee conducted a standard intake. The decedent and counsel met privately. He confirmed his intention. The trustee received a letter of instruction and supporting materials. The judge's gaze became sharper. Supporting materials? He asked. Yes, the man responded. A log and a statement. The decedent wanted them to be preserved. My sister's head snapped up. Which statement? She demanded. The judge did not look at her. Provide it, he instructed the man. The man reached into another envelope he was holding, which I had overlooked because it was thinner and unmarked, and handed it to the clerk. The clerk handed it to the judge. The judge opened it and took out a single-page letter. He read quietly for several seconds, his eyes moving with careful attention. Then he looked up at me, not warmly, but with the weight of something he recognized. Ms. Hale, he said. Did you know your grandfather prepared a written statement anticipating the allegations made that same day? Yes, I replied quietly. He told me he did, but I didn't know what he wrote. My sister's breathing has changed. Her nails dug into the counseling table. The judge examined the top of the letter, then he read the first line out loud. If you are reading this in court, it means my son and his family tried to take my estate by accusing my granddaughter. My mother made a sound as if she had been stabbed. My father's face became rigid. My sister's lawyer sat down slowly, as if he had realized he was standing on a trap door. The judge continued reading, not all of it, but enough to make the record unmistakable. He read that my grandfather had asked me to move in following his fall. He learned that he had met with counsel alone. He read that he had established the trust because he was afraid of pressure tactics and quick signature demands. The judge then reached a point where his lips appeared to press together. He read it once in silence. Then he read aloud. On the night I called 911, my son brought a mobile notary to my house to obtain new signatures. I refused. I asked for witnesses. If they call it elder abuse, they are projecting their own behavior. The courtroom was dead quiet. Not a whisper. Not a cough. My sister sat motionless, and I noticed her eyes flickering as if she was trying to find a way to survive the record. My father's attorney stood slowly, his voice cautious. Now, Your Honor, he replied, we object to hearsay. The judge cut him off. It's a statement of intent from the decedent and offered to show his state of mind, according to him. And it's consistent with the dispatch audio. He held the letter up slightly. This court is not going to entertain a last-minute elder abuse allegation used to seize assets held by a corporate trustee, he said, every word carefully chosen. If you want to file a petition with evidence, you can do so, but not on the same day. Not like this. My sister's attorney swallowed. Your Honor, he said. We'd like to withdraw the motion. The judge's gaze stayed cold. You can't withdraw consequences, he replied. But you can stop digging. He turned to face the clerk. Dismiss the motion, he said, and set an order to show cause hearing regarding sanctions for the filing and the false assertions made that same day. My mother's face went pale. My father's jaw clenched. My sister's mask finally cracked. So she gets everything, she snapped. The judge didn't flinch. The trust gets administered per the terms, he said. And yes, Miss Hale's petition to seize all inheritance effective immediately is denied. My sister's hands shook now. She tried to hide it by gripping the edge of the table. The man in black spoke again, calm like a machine, stating the next step. The trustee will suspend any distributions to parties who triggered the no contest clause until further review, he said. We will follow the trust language exactly. My sister's head snapped toward him. Suspend, she hissed. No, that's... He didn't argue. That is, he said simply. The judge leaned forward and said the last sentence my sister did not expect to hear. Ms. Hale, he said. You walked into this courtroom acting like it was already yours. Now you will leave with nothing decided in your favor that same day, and you will answer for the way you tried to obtain it. My sister's eyes turned to me again, full of hatred and humiliation. Then she whispered, barely audible. This isn't over. And that's when the bailiff stepped in close, quiet, unprofessional, and spoke to the judge in a low tone. The judge's expression changed slightly as he listened. He nodded once. Then he looked directly at my father. Mr. Hale, he replied. Remain seated. My father froze. Why? He asked. The judge's voice stayed flat. Because, he said. I've just been informed there's a deputy in the hallway with paperwork for you, and it isn't from this court. My father's face tightened. The courtroom doors opened again, and a uniformed deputy walked in holding a document with a bold header across the top. I couldn't read it from my seat, but I saw my father's face turn gray as the deputy said, Sir, you've been served. My father didn't stand. He didn't demand respect. He just stared at the deputy like the badge had suddenly become heavier than his money. What is this? He asked, voice tight. The deputy held the packet out. Service of process, he said. You can accept it here or in the hallway. My father's attorney leaned toward him and whispered something urgent. My father ignored it and snatched the papers, flipping the first page with shaking fingers. His eyes moved across the header. Then he froze because this wasn't probate. This was criminal. The judge watched him read, expression flat. Mr. Hale, he said. This court has nothing to do with that paperwork, but I will remind you that you are still under oath from earlier testimony. My father swallowed. Your Honor, he said, forcing calm. This is harassment. My family is being targeted because my daughter. The judge cut him off. Stop, he said. Your daughter is not the one who called emergency services to report a coercion attempt. Your daughter is not the one who filed a false motion in this court. Your daughter is not the one who attempted to seize trust assets held by a corporate fiduciary. My mother's mouth tightened. We were trying to protect the family, she whispered. The judge didn't soften. Then you protected it into a referral, he said. The deputy shifted his stance slightly, and I realized he hadn't come alone. 3 uniforms stood near the doors, quiet, not approaching, just present in the way law enforcement gets present when they expect people to run or explode. My sister's attorney cleared his throat. Your Honor, he said carefully. We would request a brief recess to confer with our clients. The judge looked at him like he was exhausted by the idea of more talking. You can confer, he said. But this motion is dismissed. The trustee will administer the trust, and I will see counsel back for the order to show cause hearing. He picked up his pen, already turning away from them. Then he stopped and looked back once, like he'd remembered something important. One final matter, he said. The room stilled again. He addressed the man in the black suit. Sir, he said. Does the trustee request any protective order? Yes, Your Honor, the man responded immediately. Given the attempted interference, the trustee requests an order prohibiting the petitioners from contacting financial institutions, custodians, or third parties in an attempt to access trust assets, and prohibiting harassment of the primary beneficiary. My sister's head snapped up. Harassment? She scoffed. The judge's gaze shifted to her. Miss Hale, he said. You just accused someone of elder abuse in open court without providing any evidence. You are in no position to scoff. He turned back to the trustee's representative. Granted, he said. Draw it. I will sign that same day. My mother's face was drained. You can't keep us from our own daughter, she said softly, her voice shaking. The judge's voice remained flat. You can keep yourselves from committing misconduct, he told me. Daniel Mercer leaned in and said, This is the cleanest order we could have hoped for. I nodded once, but my gaze remained fixed on my parents. My father now held the criminal paperwork in his hands and I could see the calculation changing behind his eyes. No remorse. Damage control. The judge called the proceedings to a close. The court has recessed, he said. My mother lunged toward me in the aisle as the gavel fell. Not physically, but close enough that the air shifted. You did this, she hissed. You ruined your father. I did not flinch. He ruined himself, I remarked quietly. Victoria stepped in, her voice a tight whisper and her eyes wild. You're going to lose everything, she stated. I'll make sure you do. I looked at her and kept my voice calm. You've already tried, I replied. And the trustee didn't even have to raise its voice. My sister's expression twisted. Do you believe you're safe because a bank sent a suit? She spat. I leaned in slightly, close enough that she could hear me over the hallway noise. I think I'm safe because Grandpa planned, I claimed. And because you can't bully a record. Her lips parted, and I could see her preparing to scream. Instead, she acted coldly. She turned her phone face down, as if she had just sent something she did not want anyone to see. Daniel noticed it as well. His gaze moved to her hands, then to mine. Don't engage, he muttered. We're leaving. We walked out via the side exit. The courthouse air outside was sharp and bright, as if it didn't care what families did to one another inside. Daniel paused on the curb and looked me in the eyes. Here's the concrete ending you wanted, he said quietly. Trust controls everything. The petition was dismissed. The no contest clause has been triggered and will be enforced. Your parents do not have access, and the court has just signed an order preventing interference. I nodded. And your sister? I asked. Daniel's mouth tightened. If she's a named beneficiary, she likely forfeited that same day, he told me. That's what her lawyer is realizing right now. We stood there for a moment, simply breathing. Daniel's phone vibrated. He examined it, and his expression changed in the same way it did at the airport when the officer's tone changed. What? I asked. Daniel held the screen up. A notification. Official. Short. Hawthorne National Bank's Trust Department. Security alert. The attempted access has been blocked. My stomach turned cold because the hearing had ended. The order had been signed, but someone was still trying to touch the money. Daniel's voice became quiet. They're doing it right now, he explained. I stared at the alert. And at that moment, I understood. My sister had not turned her phone face down to keep from screaming. She had turned it face down as she moved. Daniel did not waste a second. He called the trust department while we were still standing on the curb, the courthouse doors behind us, and my parents inside, pretending they hadn't been humiliated. A woman responded with the steady, rehearsed calm that you expect from people whose job it is to prevent disasters. Hawthorne Trust, she explained. This line was recorded. How can I help you? This is Daniel Mercer, he said. Counsel for Mary Ann Hale. I've just received a security alert. The attempted access has been blocked. I need specifics. There was a brief pause with the sound of keys tapping. The woman's tone sharpened slightly. Do not panic. Procedure. Yes, she answered. There was an attempt to log into the beneficiary portal. It failed the dual authentication process. Immediately after that, an attempt was made to change the phone number on file. My mouth became dry. Change it to who? I asked. The trust officer did not respond directly. She asked Daniel, are you giving me permission to disclose the attempted change request data to your client? Yes. Daniel replied instantly. The trust officer proceeded. The attempted phone number change request was submitted from a device associated with the petitioner, Victoria Hale. I closed my eyes for a half second because I could see it perfectly. Her flipping her phone face down in court, as if she were hiding shame, when in fact she was concealing action. Daniel's voice remained calm. Did she authenticate? He asked. No. The trust officer responded. The system denied the request. A manual flag has been placed. The distribution status has been changed to hold due to fraud risk, pending review. Daniel let out a slow breath. Good, he said. Stop all changes. No changes to portal contacts, phone numbers, emails, or addresses without verified in-person identification. Already done, she said. And a report has been generated. Daniel's jaws tightened. Send that report to my office, he requested. And note, there's an active court order issued that same day prohibiting interference. Understood, she replied. We have a court order on file. The trustee will comply. The call ended, and the silence felt sharp. Daniel looked at me. That alert, he said. This is exactly why corporate trustees exist. They aren't bullied. They aren't guilt-tripped. They logged and blocked. I nodded slowly. So, she tried to get in, I responded. And failed. Yes, he responded. And she just created a record that will follow her into sanctions. We drove straight to Daniel's office. Not for drama, but for one reason. To secure everything. While my family was still spinning, Daniel had me sign a brief written instruction requiring all trust communications to be routed through counsel, no direct contact from family members, and any attempted changes to be treated as fraud. He then sent the bank's security report to the judge's clerk with a note. Within a few minutes of the court recess, attempted access was blocked. No threats or speeches, just a timestamp. After a short while, Daniel's assistant entered and announced, "The trustee representative called back." The man in the black suit, Hawthorne's representative, appeared via video call. Same calm expression. Same plain suit. Similar to a uniform. "Ms. Hale," he said, "I'd like to make something very clear." I did not speak. I let him. "The trust will distribute only according to the trust terms," he added. "There will be no exceptions based on family pressure. There will be no temporary transfers. There will be no advancement." He looked down at a note and then back up. "And as a result of the same-day petition and attempted portal interference, the trustee has formally determined that Victoria triggered the no contest clause. Her distribution has now been forfeited, pending court confirmation." My chest tightened. Part relief, part disbelief. Daniel inquired, "And the parents?" The trustee representative's face did not change. "Richard and Elaine Hale's contingent distributions are under review," the politician said. "Given their participation in the petition and coordinated behavior, the trustee is treating their involvement as interference." He paused and then said, "We will file a declaration with the court." That was when it felt complete. Not because it was emotionally satisfying, but because it was administratively final. 10 days later, the court heard the sanctions case. My sister's attorney did not make eye contact with anyone. He stood up, cleared his throat, said, "Your Honor, we withdraw all contested claims," and apologized to the court. The judge did not smile. He did not accept the apology as if it erased the attempt. He imposed sanctions for the bad faith filing, ordered my sister to pay a portion of her attorney's fees, and, most importantly, issued an order acknowledging the trustee's enforcement of the no contest clause. He then addressed my parents directly. "Your daughter did not take anything," he told you. "Your father's documents took control from you, and you reacted with manipulation. This court will not take part in that." For the first time, my mother shed genuine tears. Not grief, but a lack of control. My dad did not cry. He just stared at the floor, as if looking for a loophole. There was not one. Within 3 weeks, Hawthorne National Bank finished the initial formal distribution under the trust terms. The house was still protected by title. The remaining assets were managed using receipts, confirmations, and a paper trail that my family could never erase. And as for my sister, her wealth did not shield her from a forfeiture clause she had ignored because she believed courts existed to reward confidence. They do not. Courts reward records. On the night the final confirmation email arrived, I sat at my kitchen table and opened the same folder that my grandfather had created years before. Not to repeat the pain, but to remember the lesson. When people try to erase you with a story, you don't fight back with another story. You fight the story with evidence. 17 days after the hearing, the court entered the trustee's declaration into the record. Hawthorne completely shut down the trust. There will be no changes without in-person verification. My sister's forfeiture was upheld under the no contest clause. My parents' family settlement request was denied, and the sanctions order required them to reimburse legal fees related to the false filing. Within 21 days, the trustee completed the first distribution exactly as written, and the deeded property remained protected outside of probate. No more motions. No more emergencies. Just the record was finalized.